We are ready when you are.
May it please the court, Cord Meller, on behalf of the appellant Mary Ann Johnston. I'd like to reserve 5 minutes at the end of my time.
Okay.
Mary Ann Johnston is a successful defendant in a foreclosure suit brought by Nutter and Company, and as prevailing party in that lower court action, she sought her attorney's fees under Section 57.105 subsec 7, which is the reciprocity statute that allows for such fees. The mortgage in this case was a federally insured home equity conversion loan, known to the TV advertisers as a reverse mortgage, but and we'll probably be referring to it as a reverse mortgage throughout this argument.
I was trying to understand, what was the basis of the court denying the request for fees? Trying to understand that.
Well, I'm sure I can't make the Appellee's argument as well as he will, but a case was cited at the hearing in the case 1992 case from the Third District Court, Suchman, which the lower court judge found persuasive that because I can talk about Suchman.
And there's no need. I guess in my mind, it's very clear that at least in Florida, we do have a reciprocity statute. I mean, basically, if you have, even there's case law that say, if something is unilateral, it's considered to be bilateral in terms of fees. And I was just trying to understand.
And I know that the opposing counsel will argue that it is not that it is not bilateral because of the particular provisions in reverse mortgages that don't permit deficiency judgments to be issued, to be entered against defendants when they do, or mortgagors when they do lose their homes in foreclosure. That the value of the property has to stand as security for the loan, and that I believe that's what you'll hear is the argument against the award of fees. But
there's another point that kind of occurs to me a little bit, and it's a point that's bubbled up in a couple of recent foreclosure cases that deal with fees, where a fee provision is within a mortgage instrument, and there almost seems to be this tacit assumption that the mortgage instrument is a contract to which 57.1057 would necessarily apply, and I don't know that it doesn't really get developed here, but I'm not sure that's a correct presumption.
Well, I think that the jurisprudence that's out there, and it is, I think it's more than bubbled up. It's been pretty.
Well, that jurisprudence, yes, this court and an early Florida Supreme Court decision did say that the mortgage instrument is a contract that's out there. The citation of that goes back to a Fifth Circuit case which held no such thing, which in fact said that the promissory note being unenforceable, the lien of the mortgage necessarily falls with it, which to my mind has always been what a mortgage is. It's a lien. The instrument doesn't purport to be a contract, doesn't say that, foreign consideration, which hereby is, acknowledged and mutually exchanged, da-da-da-da. In fact, the consideration of the mortgage would be exactly what the consideration of the promissory note would be. So can you help me work through that kind of, I know this is a little bit of an oddball question, but can you help me work through that so that I can kind of reconcile that with what your substantive argument today, which is that, hey, we really ought to be entitled to fees under this?
Well, certainly a mortgage is a process of negotiation, an application, a meeting of conditions, a meeting of a mind on which a lender is.
That's the note. That's the debt that is the debt that ultimately gets memorialized in the promissory note, where you have an exchange, where the bank basically has funded this loan and says, you borrower agree to repay it back at the following terms, right? That fully encompasses it. The mortgage then is just security to make sure you do that.
Yes, yeah, Judge Lucas, you're absolutely right. I mean, that's I can only say that those have been so closely conflated that
true on that.
Courts have gotten there, and so when lenders are evaluating prospective borrowers, when borrowers are evaluating the terms of prospective loans, the documents, the loan documents are the documents as they're presented at a closing. They are presented. You don't have options as to whether you enter into the note or not to the mortgage. It is a complete document.
Yeah, and there's a bunch of provisions in the mortgage that purport to act like a contract, talk about what happens if there's eminent domain, if there's, insurance proceeds because of a fire, whatever. I mean, I get it. I'm just wondering how this thing has come to be understood as its own standalone contract, which is just odd to me.
And that would be a pretty heavy lift to push that back. And
true. There's some truth to that.
Respectfully beg out of that today.
Yeah. Fair enough.
Because I know you made, and going back to the mortgage itself, and let's focus on the mortgage. There is a provision in there that basically allows for reasonable attorney's fees and cost. So that's paragraph, I think it was paragraph 20
yes, Your Honor,
of that.
paragraph 20.
And going through the facts of this case, there's no question that your client is considered, quote unquote, a borrower in this reverse mortgage thing. So the question for us, the analysis is, well, okay, she is a party. She's part of that mortgage. The mortgage says what it says about the prevailing party gets to recover attorney's fees and so forth. So as I hear your argument saying this is very clear that she should be entitled as prevailing party, in this case to be awarded her fees under paragraph 20 and under the fact that she is a borrower.
Judge Kozan, that's exactly my argument, and I would point out that the issue before the lower court in this case was whether she was a borrower, and because she was a spouse who had signed on to include her homestead rights, her spousal rights, but the husband was an older individual, and under the reverse mortgage marketing, that makes a difference. But in the preceding year or so before this case was brought, there was the case, I think it's in the 3rd district, the National Reverse Mortgage Smith versus Reverse Mortgage Solutions, which was the case in Florida that made it clear that a surviving spouse resident in the mortgage property who had been bound by the mortgage would be considered to be a borrower, even if there was some ambiguity as to what line she signed on or whether she was shown at the first of the mortgage or the last of the mortgage. Smith versus Reverse Mortgage Solutions settled that issue, and in fact, that case was remanded to the lower court, and fees were awarded, and that never was subsequently appealed. So actually, in this case, we were kind of surprised that the entitlement to fees came up. It took quite a while for that issue to bubble back, and for this.
And I thought it was interesting because the other side took the position all along, well, she's not liable. She doesn't have to pay. She is not liable. But then you provided, and there's case law to the effect. In fact, you did a supplemental authority when the Supreme Court case that it dealt with a different issue as to standing and to whether or not, even in that scenario, if somebody is entitled to fees. But the case law has indicated out there that if there has never been a contract, if you've never been in a contract with someone, surely, if you're not a party to that, you shouldn't be entitled to fees. But in this case, and looking at the facts, her being a borrower under this, I think your argument is those cases are different, and here should be entitled to it. And look at the supplemental authority that actually supports that position.
Judge Kozam, that's correct. And so you're going to talk about, you're referring to the Glass
Correct.
decision, which was rendered by the Supreme Court just earlier this year.
Correct.
Which, I will admit is still with the Supreme Court. There's a motion for clarifications pending. Also note that my colleague here is on the brief for one of the amnesty in that case.
Yes, I've noticed that too.
he can probably speak to Glass much more expertly than I can. But what was not an issue in Glass is this 57-1057 reciprocity entitlement.
Correct.
That seemed to be treated by all parties as being part of the legal landscape, that if indeed Ms. Glass once a contract could be found to exist between Ms. Glass and whoever her lender was, that the entitlement to attorney's fees would follow, which is the Smith versus reverse mortgage, sort of the affirmation of that. Even the dissent in Glass was on the basis of lack of jurisdiction because of the way certiorari was granted. But I just would like to just address the fact that there is economic impact to a reverse mortgage borrower in this kind of situation if she loses, if she violates the terms of the loan, doesn't pay the taxes, doesn't live in the house, and subsequently faces foreclosure, and the judgment is entered. That judgment will, of course, include the lender's attorney's fees, and will be, those will be added to the judgment. If the judgment is for more than the value of the house, clearly, well, what's a few more dollars? It's not going to be anybody's responsibility but the federal government who insures these loans. But in many of these cases, and I believe it's not in the record, but this was not a mortgage for greater than the value of the property. Had Ms. Johnston been required to go out and borrow the money somewhere else because she wanted to keep her home, and she had somehow let this status, this reverse mortgage status get away, it's a burden on the equity of redemption. It's less money that she ends up with from the investment that she has in her home. The fact that she's not liable for a deficiency judgment, which is by no means an automatic thing in Florida mortgage practice, but the fact that she wouldn't be liable for that in any event is not the sole criteria, I think, in deciding whether the court agrees that 57-105 sub 7 applies here. If there's no other questions, I'll take my remaining time.
You'll have some time for rebuttal.
May it please the court, David Rosenberg on behalf of the Appellee, James B. Nutter and Co.
Okay, Mr. Rosenberg, help me out, because clearly, don't you think this falls within the reciprocal provision here?
So, okay, there's a quick answer to that and a long answer. The quick answer is yes. There's a reciprocity provision in 57-105 that renders bilateral and unilateral prevailing fee attorney provision.
Okay.
Correct. The longer answer, and I won't make it too long, so more questions. The longer answer is they don't, at first glance, have a right to attorney's fees in the contract, right? I mean, that is our right. It's 57-105 that makes that reciprocal. So if you're just looking at the contract, they have no right to attorney's fees. It's just the lender.
How about paragraph 20 of the mortgage?
Right, so that's only lender. So what 57-105-7 does is it takes that attorney's fees provision, it doesn't add to it, doesn't create a new one, it just makes it reciprocal. So whatever right that the appellee, that we would have to recover attorney's fees, that's the right that Johnston would have. There's no new right, there's nothing written into the contract, you just take exactly that right and make it reciprocal. That is probably the most important point in this entire appeal. It's the most important point because it's undisputed below and on appeal that we cannot recover attorney's fees from Johnston personally.
You can recover it, though, out of the in rem, out of the property.
Exactly, in rem.
And that, in turn, affects whatever redemption or whatever equity she's going to have in it. So you are correct. You can't get a judgment based upon that a personal liability fee judgment. But what you can do is get whatever there is in the property, and that additional attorney fee amount is an amount that she is not going to get.
I agree 100%.
And in theory, if the lender then pursues a deficiency judgment, that gets baked into the pie as well, doesn't it?
We can't pursue a deficiency judgment. The mortgage, everything specifically says.
And that's why I premised, in theory, in another kind of case,
Yes,
all right, going
agreed.
with this notion that it's not reciprocal because really and truly the bank can't get it against her personally. Well, at the end of the day, yeah, it could, right? Because if the fee amount increases the amount of the deficiency, that delta is going to get recovered, and if the lender had the right to pursue a deficiency claim.
Agree 100%, and that's why this case is different from the other cases out there that normally deal with attorney's fees provision. It's different because of the no deficiency provision, which takes it out of the realm of all those other cases, and it's also different because we can't even collect attorney's fees. So deficiency, that's part of the foreclosure, really. I mean, you have the foreclosure, and then whatever is not satisfied by the sale, you get the deficiency.
Mm-hmm.
Then you also have attorney's fees, which sometimes are looped into the foreclosure action itself, and sometimes you have a collateral proceeding afterward, say if they don't have an attorney present at the final judgment here. So you'll have a collateral proceeding on attorney's fees. So that can continue separate from the foreclosure action. You can have a separate appeal on attorney's fees after the foreclosure judgment's entered, and in another case. That's not what you have here. Here, these attorney's fees, they are no different from property preservation charges, from interest, from late fees. The note and mortgage, the contract, if you will, defines them as part of the debt that is owed to us, and they are only recoverable through foreclosure. There is no meaningful difference between these fees and any other amount that's added to debt. There's no difference. We cannot recover those amounts from Johnson. She never disputes that. And so the key here is she's asking this court for the right to collect those attorney's fees from us personally, where we don't have that right. Not only do we not have that right, we may not get attorney's fees at all, even if they were looped into the foreclosure debt.
What if you prevailed in this case?
That's exactly what I was about to get to. Even if we prevailed, say our final judgment for $100,000, property sells for $50,000, $25,000 in attorney's fees. Our right to attorney's fees as part of the debt, it's conditional, it's uncertain. We might not get anything if the value in the property is not there.
But that's supposing, well, let's just assume you get the full amount, whatever. You could still, if there's a possibility, if you are entitled to get attorney's fees, then fair game, she gets the same. And that goes back to the reciprocity, which is my very first question. And so that's where I'm having some concerns there.
But I guess my point is, in addition to what I said, I mean, we don't have that. I think it's really important to look at Suchman and McCoy, and Johnson never even rebuts Suchman and McCoy on the merits, never even touches on McCoy. Obviously, this court has had a chance to read both of those. Those are really important cases, and they're directly on point. I mean, if this court was going to rule for Johnson, I would suggest it should at least explain its reasoning so there could be an express and direct conflict, if not certified conflict, with Suchman, and perhaps with McCoy. I think McCoy is very on point also with their reasoning. But in Suchman, the exact same case that you have here, and Suchman is still good law. It might be from '92. There was a 2017 case from 3rd GCA Dorcius. I cited it in the answer brief. It was a PCA with a citation to Suchman. If you actually went and looked at the briefs, exact same issue that we have here. And the PCA didn't even bother writing an opinion on it, just said see Suchman. Exact same issue that we have here. And what they said is, and it was same issue, non-recourse loan, where we couldn't recover, where the plaintiff there could not recover attorney's fees from the borrower. They said, then why should the borrower be able to recover attorney's fees from you? That's unilateral. That's not reciprocal. Because again, 57105 doesn't give Johnson a new right. It just makes reciprocal whatever right we have. And we cannot recover attorney's fees from Johnston. We can only recover it as part of the foreclosure, no different from regular foreclosure expenses against the REM. And what Johnston does in the initial brief, and to extent also in the reply brief, there's a lot of conflation between in personam liability, in REM liability. I mean, every action you have, there are going to be financial consequences. I mean, unless it's maybe a declaratory action or something to that extent. In every action, the losing side is going to suffer some sort of financial penalty. Here, yes, they're going to have to pay more in order to, if they want to redeem the property. So that's
You're buttressing your whole argument on the fact that in this case, because I know what McCoy says and I know what, so as I understand your argument, you're saying she is under no obligation whatsoever to be responsible for any fees.
100%. She never disputes that.
So how about, because the other side is saying, you know, if she is facing, I think to use his words, she'd be responsible for fees, and if she does face an economic impact in this case, so she is affected. If, in fact, she loses, she faces foreclosures, how do you respond to that?
So different from a title owner. A title owner also is entitled to, redeem the amount, or pay off the mortgage or pay off the final judgment. I mean, anybody that we name in the action who's going to be defended is going to be or potentially impacted by it. But that doesn't give them the right to fees. Fees, strictly construed, like this court was talking about just in the prior case, it's by statute or contract. That's it. So you only get it under the American rule. You only get it if it's in the contract, and then if it's a unilateral, if 57105 makes that reciprocal.
What about this? What if, well, I guess I was thinking out loud, but what if the way it would work then is almost give her a permanent credit on the fees that she prevails vis-a-vis her mortgage?
So
and at that point, now you have reciprocity, because it all relates to the REM. It all relates to the property. It relates to the debt to the property, and because there's no personal liability for her, great. She's not getting quote-unquote personal liability against the lender, but at the same time, there is an accounting for the fact that she prevailed.
So I'll be honest, I was not going to raise this unless it was brought up by one of you judges. I agree. If I were them, that's what I would have argued. I would have argued that the reciprocal of that provision.
Yeah, it's not. They didn't pitch it here, but
Exactly.
it was an idea that occurred to me that, well, you know, you could make this reciprocal even within the narrow confines of just give her credit.
That's what I would have argued. I would have argued that it should be added to the loan balance as a negative. But that's not what they argued here. So I don't think this court's opinion should address that. If it writes an opinion. But I think that would, Judge Lucas, be the reciprocal of it. It would not be reciprocal to allow Johnston to recover attorney's fees personally from us, where we cannot do that against Johnston. I thought the McCoy decision, 4th DCA, said it very well. Without an obligation to pay fees, and Johnston has no obligation to pay fees herself, there is no basis to invoke the compelled mutuality provision of Section 57105.
Let me put it just a totally different hypothetical. Your client brings in a totally frivolous action against her.
I'm sorry, could you say that again?
Your client brings a totally frivolous action against her.
Yes. Then you'd have 57105 subsection 1. They should have, in that case, they should have moved for sanctions, and they could have gotten it. So there's a basis for that. You know, if that was the case, then they could recover fees under that as well. Or, I mean, they could still recover them if they had argued under Judge Lucas, as he said, a negative, add that to the balance as a negative amount.
Because here, I mean, very clearly, she was a borrower. She is part of that, and that's why your client did not prevail.
Right. I mean, that is the law of the case. We never disputed it. I mean, I will note offhand the law has evolved since that was entered. It's no longer clear if you could wind back the clock, whether she would still be considered a borrower or not under Palmero in 3rd DCA's when it revised Smith on rehearing. I mean, there could be some argument there as to whether, I don't think this is frivolous at all. I think we proceeded on a good faith basis. We elected not to appeal on the law that was in existence at that time. If I had this case now, I probably would.
Did you appeal, or then you withdrew the appeal, or is this case, or am I?
You're correct, but we didn't proceed with the appeal. But you are correct, yes. We filed it, and then it was dismissed. It was
Because she had to get an attorney, she expended, she had to defend, she prevailed.
correct.
And very clearly under this, your clients didn't make a big issue of it, so that's the concern. And then you're dealing,
I understand what Your Honor is saying. I guess my response to that would be that, and the brief makes a lot of these public policy equitable considerations. Whether we like it or not, that's not the rule, that's not the law on attorney's fees. It's by statute or contract, period. And here, it would be by contract, 5715 would make that reciprocal. That's the only basis on which they moved. That's the only basis on which they can get fees. Again, they could have moved under subsection 1. They could have come up with a more creative argument, perhaps, like Judge Lucas suggested. If she wanted to get a negative balance, that's not what happened here. They moved under 571057, which just makes it reciprocal. And if this court were to adopt the position that they can recover fees from us, then necessarily, if we're going to have this level playing field that 5715 talks about, the inverse of that is that we could recover fees from them personally, which is not what these elderly homeowners thought. It's not what the parties intended when they entered into this agreement. We don't want to collect attorney's fees from elderly homeowners. That wasn't what we wanted to do. And if they're going to have that right, then necessarily we give that right as well. Otherwise, you're creating a new right for them after the fact and rewriting the contract. So I do understand what you're saying, but I think it also has consequences if this court rules that way, because if this court rules that they can collect fees from us, then we would be able to collect fees from them. I mean, if that's going to be the court's interpretation of the contract. And I mean, I don't think when you reverse mortgages, elderly homeowners, they're saying just give me a line of credit, take the property when I pass away, otherwise I don't want to be involved. They're not thinking, okay, they're going to take my house and my money and leave in the tree, and we don't want to do that. We don't want to take attorney's fees from them. That's not what the parties intended when they entered into this agreement. And that's been my impression throughout, and my gut feeling throughout this whole case is just that this is after the fact trying to change the contract. It's undisputed that we can't recover fees from them. They never, ever claim that we can, and we can't. We don't want to. So then how can they recover fees from us? It's not in the contract. It would only have to be through the reciprocity of subsection 7. Then they only get what we get, and if we can't get it from them, they can't get it from us. Just a couple of the points, if there's of course no questions on those particular issues. There were some arguments about deferred liability, surplus, things like that. Those were raised for the first time in the reply brief. They weren't raised in the initial brief. They weren't raised below. In any case, I'd alert this court that I believe that counsel is mistaken. The surplus would only come up after the judgment amount was satisfied. So it's not as though any amounts that are added into the foreclosure judgment would affect the surplus, because the surplus only comes into play, first off, even if there's value in the property, and second, will only come into play after that judgment is satisfied. Just as an aside, but again, that wasn't raised below, it was just raised for the first time in the reply brief.
Sir, you're at the end of your time.
In sum, ask this court to affirm. Thank you very much.
Okay, thank you.
May it please the court, I think clearly, as the transcript from the lower court of that brief hearing at which entitlement was determined, as the transcript shows, the trial judge was relying on the Suchman Commercial Center case, which was a long time ago in a district far away. But
not that far. It's a drive, but
but in both that hearing and in I think in the Appellee's brief, you'll see the term, the word exactly used in describing that case as being exactly like this one, and I had some points as to why it's not. It was not a home equity foreclosure case. It wasn't even a residential case. It was not even a foreclosure. If you read that case, you see that the borrowers are referred to as the plaintiffs. So this was a dispute between sophisticated parties arguing over the terms of a partial release clause in a big project. And the core ruling of the district court in that case was that the court's summary judgment in favor of the lender on whatever the dispute was, and the opinion doesn't get into any of that, but that the core ruling of the district court's opinion was to reverse and send it back to the lower court because there were genuine issues of interpretation on the contract. Not very helpful to the litigants, but apparently they worked it out because it never comes back into the appellate cases. Related to that ruling was a ruling that required the parties to restore a balance that had been paid out of deposit with the clerk. And also related to that ruling was a reversal of an award of attorney's fees to the lender, which had been predicated on the summary judgment. And so the appellate court just was restoring the status quo.
Yeah, except if the appellate court had just said, hey, in order to get everybody back to square one, we're going to reverse the fee award, I think you'd be on solid ground with that argument. The problem is they do make an interpretation issue here.
They then go on, and this is why we in our brief refer to this as dicta. It wasn't necessary for them to get to that point, except, and I'm going to assume here because I don't know anything more about the case, but that there were motions for appellate attorney fees, and so the last line is the court's. I'm sorry.
It's dicta if it's not necessary to resolve the issue before them. It's not dicta when there's an alternative way they could have done it. They chose not to do it that way, but instead expressly say, no, we find that this isn't reciprocal in this case. That's not a dicta, it's a holding. I mean, they could have gotten there a different way. They deliberately chose not to. Instead, they chose the path of saying, this is not reciprocal, and because it's not reciprocal, you're not entitled to fees. I mean, I just don't see how we could write an opinion in your favor in this case without seriously distinguishing that third DCA case, if not certifying conflict with it.
Well, it certainly isn't a case that's been cited a whole lot anywhere other than the third district, and so I think there's three cases which cited all together in that 20-some-year history. But I submit that it is distinguishable, and the court can do that. I submit that the court can rule in favor of the appellant here under the pronouncement of the Supreme Court in Glass, although not a specific holding. There's nothing in that well-briefed, well-argued case that says anything that 57105.7 should be applied against borrowers who successfully defend.
Thank you. Thank you, sir. Thank you both.
Thank you. It's a very interesting issue. Thank you.
All right.